Hearing in the appeal Vedanta Resources PLC and another against Lungowe and others.
Yes.
My ladies, my lords, I appear on behalf of the defendant appellants Vedanta and KCM with my learned friends Geraint Webb QC, Onyen Miletic and Christopher Adams. The claimant respondents are represented by Richard Hermer QC, Marie-Louise Kinsler QC, Robert Weir QC and Edward Craven. And the court has granted 3 interveners permission to intervene: the International Commission of Jurists, ICJ, the Corporate Responsibility Coalition Limited.
Yes, we are aware of who the parties to this case are.
I'm grateful, my lady. My lady, I'm very conscious indeed that the court has had lengthy written submissions.
So are we.
And there is a great deal of paper. I hope to mitigate that during the course of today as best I can by boiling the case down with the assistance of my case.
Well, thank you very much indeed for that indication. We appreciate that this is a very important case, and there are other cases that are following on behind. Nevertheless, the length, in particular, of the appellant's written case is about 3 times that which we normally regard as the maximum in this court. This court is only concerned with points of law of general public importance. And we're not concerned to review the facts. We're not concerned to review the exercise of discretion. So it could have been boiled down very much more than it was, nor was it necessary to supply us with these huge quantities of background material. That is not the way in which we approach decisions, important though this is. And I hope people will bear that in mind in the future, and also it may very well be reflected in whatever costs order is made.
Yes, of course. My lady, we heed those words, and I, of course, entirely understand the importance of focusing on points of law and principle of public importance. I hope it may be clearer why there are factual issues I need, with some trepidation and sensitivity, to take the court to, but I'll seek to do it as quickly as I can. My lady, subject to the court, of course, my proposal this morning is to deal with ground 1 of the appeal, that is the common law duty and the statutory duty, and all being well, move briefly to forum, and then this afternoon deal with forum, access to justice, and my learned friend Mr. Webb will briefly deal with the Vedanta appeal. So, my lady, turning then to ground 1. And if you'd be kind enough to take our written case, it's MS page 74, which is at E2, paragraph 32. This ground of appeal concerns the question whether there is a real issue which it is reasonable for the court to try as between the claimants and Vedanta. And the claimants rely on 2 broadly causes of action against Vedanta. One is the common law duty of care, and secondly, 3 Zambian statutes, which I will turn to later this morning. So far as the common law duty of care is concerned, I propose to approach this under the following 6 broad topics. First, the findings and errors, we say, of the courts below in their approach to duty and reliance on Chandler.
Why don't you start with first principles rather than bothering about what the courts below got wrong? That's what we do.
Yes.
We ask ourselves, what are the principles
Yes.
of the liability at common law of a holding company for the shortcomings of its subsidiaries?
The reason, my lady, is that one of the fundamental errors, we say, of the courts below was in the way it approached the summary judgment test, and it approached the question of whether the duty was owed. In other words, the judge at first instance, supported by the Court of Appeal, held that there is such a thing as a parent company duty, and it depends on the facts whether it's owed. We say that was wrong, and as a result of that, the judge and the Court of Appeal did not investigate or critically analyse the facts said to support the duty, as they should have done, we say, in accordance with the summary judgment test. Boiling it down then, my lady, on my first topic, I'll go straight to it, and I'll come to the others in a moment. Boiling it down, this is what the judge found, and then we'll move to cases and principles. The judge found that, and this is paragraph 36 of our case, where we've sought to do that, MS 76. You start with Caparo, and in the light of recent judgments, one can see that may have orientated the court away from looking at the significant legal facts of the other cases. But essentially, he said, you start with Caparo. He looked at 5 cases, 3 interlocutory cases, and the only 2 decided cases in this jurisdiction involving parent company liability, Chandler and Thompson. And on the basis of that overview of the cases, he determined that, depending on the facts, it is arguable that a claim in negligence against a parent company arising out of the operations of its subsidiary might give rise to a liability, as in Chandler. And as we say in paragraph 39 of our case, by reference to Chandler, he said, it's not necessary to look at the evidence because that would involve a mini-trial, but the pleading represents a thoughtful and detailed attempt to get the claimants within the scope of duty found to exist in Chandler. By reference to the 4 indicia, it's an uphill struggle, but that is sufficient. And the Court of Appeal essentially reviewed the same cases and concluded that the judge was entitled to reach the conclusion he did in paragraph 90 on the basis of the way the case was pleaded. So if this is the law, and if this is the proper approach to the test, it is sufficient in a parent company case simply to allege that the parent company exercises control of some sort over those affected by the operations of a subsidiary. It's sufficient simply to plead the duty by reference to what I'll show you have been called the Chandler indicia. Further inquiry is a mini-trial and is inappropriate. So, my lady, my submission is that that is wrong as a matter of law, and that the huge amount of evidence that has been adduced is unnecessary and inappropriate. But in fact, it's of necessity we've had to look at it, as the Court of Appeal did in the Shell and Unilever cases, because essentially the claimants say the duty is owed, it depends on the facts. Here are a number of documents, mostly in the public domain, that demonstrate how this parent company has generally operated in relation to the subsidiaries in the group and has, for example, disseminated group-wide policies. And it's alleged that demonstrates Chandler control or Chandler liability. So in my position, my lady, facing that allegation that is a duty in law, one can either say it's not, which is what I will seek to persuade you, a duty of this nature and scope is not arguable, and that's the bold approach, or in addition to that, you do what I confess to doing and what was done in Unilever and Shell, which is you meet all the evidential arguments to prevent the claimant saying that the defendants have no answer to them. But my lady is absolutely right. We respectfully submit that legally we are not at the edges here. A duty of this nature and scope is wholly unarguable. It is demonstrably not a Chandler case. The Chandler indicia do not apply to a parent company situation. It is a novel duty, therefore, and one, if one does carry out a proper review of Chandler in particular and the significant facts of that case in order to ensure that the law progresses incrementally and cautiously, one sees immediately that there is no analogous category. Parce, the learned judge, and the Court of Appeal. So, my lady, that deals with my first topic, the findings and errors of the courts below. I then propose to respond briefly to the claimant's arguments about the proper approach. Thirdly, to look at the nature and scope of the duty that is pleaded. Fourthly, to analyse the authorities, and in particular Shell and Unilever. And then, briefly, of course, critically analyse the evidence just to show you that this is not a management control case. And finally, sixthly, to summarise why the claimants, we say, do have no realistic prospect of establishing that this novel duty would represent a cautious and incremental development. And having dealt with the common law duty, I'll then move to the statutory duty claims, my lady. Standing back for a moment before I start, the Court of Appeal in Shell and Unilever adopted a completely different approach to a very similar series of allegations that the parent company in Shell and the parent company in Unilever owed duties applying control theories and the Chandler indicia. The big difference between what the Court of Appeal did in Unilever and Shell and what happened in Vedanta was that the Court of Appeal did subject the evidence that was adduced by the claimants in support of the alleged liability to critical scrutiny. And as the Chancellor said in Shell, it is important that the judge does it. He said there's a tension because he deplored the amount of material, my lady, as we all do.
Can't have it both ways, surely.
No, that's why he said there's a tension. He said there's a tension here because I agree with Lord Justice Simon, we don't want all this material, but I've looked at it. And having looked at it and given it critical analysis, I'm satisfied that it does not demonstrate the alleged control by the parent company, which would need to be established, the significant management takeover, which was the way Lord Justice Sales phrased it in Unilever, that a claimant would need to establish to stand any prospect of demonstrating that a parent company applying principles of law and not special principles applicable to parent companies, principles of law actually owes a duty in Shell, and in this case, not just to the employees of the subsidiary, but to those affected by the operations of the subsidiary, their land and their person. And my lady, if this duty exists, it is an omission duty, which is what Chandler is. Vedanta owes a duty to intervene in the operations of all of its subsidiaries worldwide, because it owes a duty of care to all those potentially affected by the operation. So,
of course, it's not impossible, is it, that a proper examination of the facts would show that the level of control exercised by Vedanta in relation to mining operations in Zambia was different from the level of control that it might exercise elsewhere. And the only thing that matters in this case is the level of control that it exercised over the Zambian operations.
well,
This is an interorum argument which doesn't actually
my lady,
take matters much further.
I'll meet that point head on. And on a proper analysis, this is an omission case. The core of the allegation is that Vedanta failed to intervene and exercise suitable control.
No, the omission is the breach. obviously, duties as far as omissions are concerned are different from duties of to avoid acts. That's almost A-level law, isn't it? But nevertheless, there are exceptions to that, and that's why I was making the point that one of the exceptions is the level of control,
yes.
and the level of control could, on the facts, be completely different as between the holding company and different subsidiaries, or even different operations.
It could, my lady, and that is why, particularly at a jurisdiction stage, where one is applying the real issue test, the summary judgment test, we respectfully submit it's important to subject the allegations and the facts to critical analysis, because unless you do that, you can't see whether or not the test has been properly applied and the hurdle has been overcome. And we submit that this case, in fact, when you submit the facts to critical analysis, is very similar. I know the cases are all different, but it's very similar to Shell and Unilever. In Shell and Unilever, the claimants relied on the corporate governance framework. And my lady, they're not just interim arguments, they're simply seeking to explain what the nature and scope of this duty is. It may be that it's alleged it's owed to Vedanta, but in fact, when one looks at the pleading, the basic pleading, based on the corporate framework and the corporate structure, alleges that there is a duty which would be owed worldwide. It is correct that in addition, the claimants rely on certain pieces of evidence which they say do support the type of direct control that you are, my lady, is referring to. But this is a classic example of what I've been seeking to say. When you look at those points that they make, when you look at those pieces of evidence they produce, they do the opposite. And when you look at the evidence, which is not in dispute, we're not asking the court to conduct a mini trial, you see, in fact, that if this duty is owed, it is a duty that would require Vedanta to take over and become involved in the operations of a mine it cannot lawfully operate. KCM alone in Zambia is permitted through a license which is heavily regulated to operate this mine. So the duty involves, if it exists, vis-à-vis Vedanta and KCM, Vedanta taking on an operational role which it couldn't lawfully take on. And the irony is, if that's the right word, that the corporate framework that the claimants rely on, my lady, to say that there is this level of control expressly stipulates, as is common with multinationals with similar frameworks, but in this case expressly stipulates that KCM and all Vedanta's subsidiaries must put in place their own policies. In other words, the parent company issues broad policies worldwide, and under the framework which is relied on in order to impose the assumption of responsibility, the duty, under that very framework, the subsidiaries, including KCM, are obliged to implement the policies themselves, assure them themselves, and they are audited by a third party. So it is as stark as that, my lady, when one subjects it to due scrutiny. So may I then look at the case of Chandler, which is, and I go to it first before showing you the pleading and the duty, and it's in Authorities Bundle 1, Divider 8, because this is the legal basis for the way the duty is alleged. And this is obviously contains the Chandler indicia, which are relied on by the claimants essentially to make out the proximity between the claimants and Vedanta and the claimants. It's at MS 3173, Divider 8 of Authorities Bundle 1. And as you can see from the beginning of the headnote, the claimant was employed as a brickloader in 1959 and 1961 to 62 by a subsidiary of the defendant company. Asbestos was also produced on the site where he was employed in a factory with open sides, and dust from the factory migrated into areas where the claimant worked. And he contracted, sadly, asbestosis and brought a claim against Cape PLC, the parent company, because the subsidiary was no longer in existence. And Lady Justice Arden, who delivered the judgment of the court with the judgment with which Lord Justice Moses and Lord Justice McFarlane agreed, starts her judgment at MS 3175. And as she says at the beginning, the principal issue is whether Cape owed a direct duty of care to the employees of its subsidiary to advise on or ensure a safe system of work. Now, this is the case that the claimants rely on as the category that is applicable to, in this case. She then reviews the evidence, and the review is, we submit, important, but it's not necessary for present purposes to be delayed by it. But I'd point out on paragraph 30, on page 3181, she summarises over the next two pages, 3181 and 3182, the findings of the judge, which essentially, she says later in her own reasoning, she endorses. Could I draw your attention to certain points, not all of them because they are repeated and endorsed, but first of all, at letter E, and it's the fourth point that is made, the right-hand side of the page, 3 lines down from letter E on the left. Cape Products inherited the working practices which the defendant had adopted for the production of asbestolux at the factory at Uxbridge. So the subsidiary inherited the working practices and the equipment, and it was making asbestos boards called asbestolux, and as we see later, it was making them to the parent's specification. And she goes on to say, there's nothing in the minutes of the Board of Directors of Cape Products which suggests that any kind of change in working practices occurred in the years following. And then over the page, Lady Justice Arden, again citing the judge at the top of 3182, between A and B, says, in particular, as is clear, asbestolux was produced in a building which had no sides. Dust was permitted to escape without any regard for the consequences. This was no failure in day-to-day management. This was a systemic failure of which the defendant was fully aware. And then at letter D, the judge found the defendant retained responsibility for ensuring that its own employees and those of its subsidiaries were not exposed to the risk of harm through exposure to asbestos. And at 76, the judge noted, no argument was advanced to me by Mr. Feeney that if foreseeability and proximity were established, nonetheless it was not fair, just and reasonable for the duty to exist. So they were solely looking at issues of proximity. Lady Justice Arden dealt with the law at paragraph 62, MS page 3188. And she says at the beginning of 62, and this is the basis of the duty in this case, it is alleged, there was a duty of care on the basis of an assumption of responsibility, first line of paragraph 62 and second line. She then reviews Caparo, notes that proximity is a label, and I know this court is very familiar with that jurisprudence. And then, as my lady pointed out, At A, page 3189, she draws attention to Smith and Littlewoods and says Lord Gough recognised that there were exceptions to the Smith and Littlewoods general no duty to prevent third parties causing damage principle, namely if there's a relationship between the parties which gives rise to an imposition of or assumption of responsibility on the part of the defendant. And then in the following paragraph, as this court has said on a number of occasions, she says that perhaps the better word is attachment of responsibility because that more accurately reflects what the court is actually doing. She then notes Dorset, Gray, Clay and Crump. She notes the interlocutory decisions that the judge referred to in our case, which I'll take you to very briefly, Connolly and Thor. And then over the page, at 69, she emphatically rejects any suggestion that this court is in any way concerned with piercing the corporate veil. A subsidiary and its company are separate entities. There's no imposition of assumption of responsibility by reason only that a company is the parent company. The question is simply whether what the parent company did amounted to taking on a direct duty to the subsidiary's employees. Then she has overall assessment of the evidence, and this is the key area for the significant legal facts that we respectfully draw your attention to, and it starts at paragraph 72, and it runs through to paragraph 80, and it's against the background of these significant facts that she sets out her criteria and indicia. And I respectfully submit that these facts and their significance was not taken into account adequately by the court below. Had they been, it would have been obvious, we respectfully submit, that we're not dealing with a Chandler case. So looking at the facts, she says at the bottom of 72 that Mr. Stuart Smith had been submitting that there's no evidence of various things having happened, and she says, I don't find this surprising because what is complained of is not taking steps, but an omission to take steps or to advise. And she goes on over the page identifying the various facts which led her to conclude that it would be appropriate in this case to attach responsibility and to find the requisite proximity between Cape PLC and Mr. Chandler, an employee of the subsidiary Cape Products. And one sees those facts, and the core facts, we would say, between 74 and 79. And I'd ask you in particular to note paragraph 74 and 5, and you'll see from the final two sentences of 74, she emphasizes what went wrong here was that Cape Products failed to maintain there's no evidence that what went wrong here was that Cape Products failed to maintain some extraction machines. As the judge observed, final sentence, the problem was systemic. The configuration of the asbestos factory dated back to the time when Cape introduced its Pluto board manufacturing business into the Cowley Works. That's the factory we're concerned with. By installing its business there, it must have implicitly undertaken a duty of care to ensure that its business was carried on without risk to employees in the other businesses of Cape Products carried on at the Cowley Works. In due course, it required Cape Products to purchase this business. Nonetheless, despite the sale, it maintained a certain level of control over the asbestos business carried on at the Uxbridge. Products were, for instance, to be manufactured in accordance with its product specification. Product development with a group chief chemist was carried out in the central laboratory at Barking. Cape, moreover, and this is crucial to the finding, had superior knowledge about the asbestos business. It was in a substantial way of business, and its resources far exceeded. 76, added to those factors, was the role played by Dr. Smither. Whether or not he was formally appointed group medical advisor in the relevant period, it's clear he was engaged in research based on empirical based on empirical research done at CAPE and its asbestos-producing subsidiaries about the relationship between asbestos production and asbestosis. And against that background, paragraphs 77 and 78, she again focuses at 77 on the systemic failure and the fact that in 77, CAPE knew that Uxbridge asbestos business was carried on in a way which risked the health and safety of others. And then again, the emphasis in 78, given CAPE's state of knowledge about the works and its superior knowledge about the nature and management of asbestos risks, I have no doubt that in this case it is appropriate to find that CAPE assumed the duty of care either to advise CAPE on what steps it had to take in the light of the knowledge then available to provide those employees with a safe system of work, or to ensure that those steps were taken. And she says, it was a direct duty, there was an omission to advise. My lady, it's against that backdrop that she then went on in paragraph 80 and said, and this is the basis for the pleading. In summary, the case demonstrates that in appropriate circumstances, the law may impose on a parent company responsibility for the health and safety of its subsidiaries' employees. Those circumstances include a situation where, as in the present case, one, the businesses of the parent and subsidiary are in a relevant respect the same. And you've seen the facts, and they, of course, were, and that was important. Second, the parent has or ought to have superior knowledge on some relevant aspect of health or safety in the particular industry. Three, the subsidiary's system of work is unsafe, as the parent knows or ought to know. And four, the parent knew or ought to have foreseen that the subsidiary or its employees would rely on its using that superior knowledge for the employee's protection. And she goes on to say, for four, it's not necessary to show the parent is in the practice of intervening. The court will look at the relationship. The court may find that four is established where the evidence shows the parent has a practice of intervening trading operations of the subsidiary, for example, production and funding issues. Now, my lady, in our submission, this is not an analogous case.
You must be right about that, Mr. Gibson. Paragraph 80 is obviously extremely helpful so far as it goes, but we're not bound by that.
No.
And this is surely a question of incremental development or no incremental development.
Indeed, absolutely. This is a novel duty.
So to say that our case is quite far removed from Chandler doesn't really get us very far.
Well, save to the extent that the judge held that it was removed, but arguably Chandler, and that was sufficient, and the approach he adopted was to say there's therefore no need to look at any of the evidence relied on. In my submission, that's wrong in law. If it's not a Chandler category, the question I appreciate then is the legal one. What category is it, and does this case arguably fall into it? The problem with that is, and why I was going to take you to the pleading, is that this duty tends to morph and assumes different characteristics. And that is why I was so intent on spelling out exactly what it is. Because I take my lady's point. One could have a pleading that says the parent company controlled the subsidiary. Is that sufficient just to get over the summary judgment test? We say, no, you have to demonstrate some basis for saying that when the evidence all points the other way. If you then, certain factors are set out which are alleged to show that the control exists, then it's necessary to subject them to critical analysis, and one can quickly see that it doesn't exist. And my short submission, my lord, on this is not a novel increment, is that when you incremental development of the law, when you analyse this duty, by reference to the pleaded case, it is attempting to be a Chandler omission duty.
But can I just try and keep the divide between fact and law?
Yes.
You said the duty morphs. Well, the duty is that which is for protecting someone from harm by a third party, and will depend upon, one of the two examples given is an assumption of responsibility. The other one is slightly more difficult to understand because it's talking about the imposition of a responsibility, which almost begs the question. But take the assumption of responsibility point. That's the duty, and it is then either manifest that there is an assumption of responsibility from the facts, or it isn't. Chandler says, well, it can arise on the following four factors, and it does here, but it's by no means an exclusive list. And it's not, when you say it's a novel duty, maybe a novel application of the duty, because no case has been precisely the same as this one, but is it a novel duty?
Well, my lady, it depends to what extent one treats duties as broad categories of duty or more focused duties, in line with discussions of members of this court in recent duty cases. You could say it's a Smith and Littlewood's duty. It is an assumption in the sense that it's one of Lord Gough's exceptions to a duty to intervene to prevent harm. And therefore, at a very broad level, that's what it is seeking to be. But the reason I say it morphs is that my learned friend is now saying in this court, in the light of some dicta from Lord Justice Sales in Unilever, that the category of duty we are dealing with is a management takeover duty. Because he recognises, and Lord Justice Sales in Unilever, you can look at it, said, rather as your ladyship has, that, and my lord, Chandler has provided useful guidance. It is not a separate category of duty, broadly speaking, Lord Justice Sales opined. He said, it is necessary to apply normal principles of the law of negligence to this situation. There's no special category to which you apply a parent company duty. He said there, broadly speaking, could be two types of category which might give rise to a duty. One is where the parent company has taken over management control of the subsidiary in such a direct and substantial way that it is possible to say, arguably on the facts, it's assumed a duty to those who may be affected by the operations it's taken over. And in Unilever, he said that's plainly not arguable here, having looked at the allegations in the case. Alternatively, he said, and the Chancellor said a similar thing in Shell, it may be an advice duty. You may say that the parent company assumed a Hedley, Byrne and Heller type Spring and Guardian assurance, provision of services, advice duty. But this case doesn't fall into that category. So, my lady, yes, I accept when one's considering duties, one can, in a sense, always find a broad category. But if one is looking for the focused category here, we respectfully submit the court below was wrong to say that the category is parent companies can owe a duty, the rest is fact. If that's wrong, which we say it is, and one's applying the proper incremental approach and looking for analogous cases, one starts with Chandler, because the whole pleading is pleaded around Chandler. As my lord says, it's not that. So one asks, what is it? It's an attempt to articulate a novel duty, and then one asks, what is it that arguably gives rise to the assumption of responsibility? What is it that arguably puts these claimants living in the vicinity of the mining operations of KCM in Zambia, and given the broad way in which the duty is pleaded, I would add, those living within the vicinity of operations worldwide, but focusing on Vedanta, what is it that puts them in a relationship of proximity, such that the law says this is arguably a duty of care. And I think that's what Lady Justice Arden meant when she said assumption of responsibility, it is circular, my lady, can sometimes be misleading, because in effect one is looking at the relationship in order to determine whether, having regard to analogous cases, the relationship in question is one which arguably gives rise to the label of proximity. When one looks at the exceptions, the legal exceptions to the general rule that a party does not owe a duty to prevent another party harming a third party, the control exception cases are cases like Dorset Yacht, Lewis and Carmarthenshire, where there's plainly a very, very close relationship, and where, as in Dorset Yacht, the risk of harm, we would respectfully submit, was so foreseeable and clear, given the nature of the outing that the Borstal boys were on at the time, and the fact that they were next to the yachts. That enabled the court to say there's sufficient control here, or there ought to have been sufficient control for proximity and justice and reasonableness to be made out. So my learned friend can't have it both ways. On the one hand, and if I may, I'll show you, this is pleaded as a Chandler omission case, which leaves one asking, what is it that has put Vedanta in a relationship of proximity, arguably, with these claimants? Answer, the corporate structure. Or it's a case where it's pleaded, and it's not, but assume it is, that what Vedanta actually did was take over management control of KCM. And if one applies the realistic prospect of success properly to that, and looks at the evidence in relation to that, it is manifestly not the case. So, could we just look at the cases that at least led the courts below to say this is an arguable duty, and then look briefly at Shell and Unilever, and then look briefly at the way this case is put, and I'll show you the similarities. If you would be kind enough to go to my case at paragraph 74, which is MS 90. There are three interlocutory cases, Ngobo, Connolly, and Luby. We submit that none of those are analogous or of any particular help. Dealing with them very briefly in turn, Ngobo, which is at MS 3284, is a case in which the parent company actually exported a dangerous plant, process, and systems. It was an application to strike out, and Mr. Justice Kay, applying the strikeout test, which is of course different to the summary judgment test, was unwilling to strike it out, given the fact that the allegations were, as I say, of a parent company actually exporting a dangerous plant in order to circumvent stricter health and safety requirements in this jurisdiction. Connolly, again, was a strikeout application, and Mr. Justice Wright refused to strike that case out in circumstances where it was in part alleged that the parent company had, through its own supervisors, the RTZ, the Rio Tinto Zinc supervisors, implemented and supervised health and safety at the subsidiaries uranium mine in Namibia. So again, he simply said, I'm not willing to strike it out in the light of that allegation, which could arguably give rise to a direct duty, in part in view of the role of the employees.
What's the MS reference number to
It's
Connolly?
MS 3284, my lady.
No, that's Ngoma.
Oh, Connolly. Connolly is 2195. 3195.
Thank you.
Lubby was a forum case, and therefore the merits were not in issue. And in the course of a forum application, when discussing the proper place, or appropriate place for the trial, Lord Bingham noted that it was alleged that the parent company had taken over de facto control of the subsidiary, and in the light of that, he discussed where the issues relating to that allegation would be tried. In our submission, none of those cases would fall into what this court has recently described when looking for analogous cases as clearly established authorities or clearly established categories. There are only 2 cases in this jurisdiction which have actually gone to trial in which it's been alleged that a parent company owed a duty of care to employees. One is Chandler, and I've taken you to that. The other is Thompson, and we deal with that at paragraph 81 of our case. And it's important, my lady, because Lord Justice Tomlinson and the Court of Appeal made what we respectfully commend to the court are important qualifications and explanations about Lady Justice Arden's indicia. We set them out at the qualification out at 83, where they referred to the first of her indicia, same business. And Lord Justice Tomlinson said,
Where do we find Thompson?
It is at 3426, MS 3426.
Thank you.
He said, thus the first of Lady Justice Arden's indicia is not satisfied. This is no mere formalism, for as the balance of her indicia indicate, what one is looking for here is a situation in which the parent company is better placed because of its superior knowledge or expertise to protect the employees of the subsidiary companies against the risk of injury, and moreover where, because of that feature, it's fair to infer that the subsidiary will rely on the parent deploying its superior knowledge in order to protect its employees from risk of injury. We refer in our case in footnote 126 to two Australian cases, that's MS 91 and 92, CSR Limited and Wren on MS 91, and James Hardy on MS 92, and the references are given there in our case in the footnote in the authorities bundle. It's not necessarily to go to them, but Wren is an example, CSR and Wren, of an Australian case in which there was a management takeover of an asbestos factory by the subsidiary. Its own employees were running it, and therefore a duty was held to exist. So it's of some interest, perhaps. So there's no case in this jurisdiction, and no case that decided case I'm aware of, in which the duty that we're concerned with, namely a duty not held to exist to employees, but to those affected by the operations of subsidiaries, has been held to exist. That was the nature of the duty argued for in part in the Shell and Unilever cases. And we deal with those cases in our case at paragraph 84, MS 96. Could I just make 3 points in relation to these two cases? The first point I mentioned to my lady earlier this morning, but in these two cases, the Court of Appeal and indeed the judges at first instance did subject the evidence to critical analysis, and having done so, concluded that the alleged duty was not arguable. And secondly, both cases, like our case, were broadly pleaded by reference to the Chandler model. Parent company is in the same business as all of its subsidiaries. Because it issues policies worldwide, it has superior knowledge, and so on. Could I just highlight certain features of Shell, because I appreciate obviously the facts are different, but there are a number of similarities. It's in the authorities, Volume 1 at tab 14, MS 3327.
So I thought you said there were 3 points. I've noted 2. One is the subjection of the evidence.
Yes, I'm sorry.
The second was the broad pleadings by reference to Chandler.
And the third was that they essentially dismissed the same arguments we faced as of mini-trial or no disclosure. In essence, the court said it's not necessary to conduct a mini-trial, it's simply necessary to subject the evidence to critical analysis. And
Thank you.
you can't base jurisdiction on what may turn up. You have to demonstrate that you have an arguable case based on the pleading. So, Shell concerned claims by members of communities in Nigeria claiming damages in respect of pollution caused by oil spills. And the pleading set out the Shell corporate structure, which is very similar to the Unilever corporate structure and in many respects, the Vedanta corporate structure. Essentially, the holding company issuing group-wide policies, those policies being implemented by the subsidiaries and audited in different ways depending on the structure. The allegation in both cases, as in our case, was that that structure gave rise to control and gave rise to the proximity required between the parent company and those affected. And the Court of Appeal distinguished between two scenarios, first of all, at paragraph 85.1 and 2, and if I could just summarize these without going to it, we deal with it in our case at paragraph 85.1 and 2 on MS 96. A parent company which controls or shares control of the material operations, as you see from the quotation at the beginning of 85.1, and the parent company which issues mandatory policies and standards which are intended to apply throughout a group of companies in order to ensure conformity with particular standards. The issuing of mandatory policies plainly cannot mean that a parent has undertaken control of the operations of the subsidiary, and necessarily every subsidiary, such as to give rise to a duty of care. We rely on that approach and that summary in our case. Secondly, the court considered what is meant by control in this type of case. And we've highlighted in paragraph 85.3 the section of the judgment where, and it was in a number of sections, but where the nature of the control one is looking for was articulated. The parent company, whether the claimants have a good arguable case that the parent company, what they did, involved itself in the management of the operation and security of the oil pipeline facilities in such a direct and substantial way, exercising a degree of real control in relation to those matters, going significantly beyond the mere setting of group-wide standards. So that was the test that was applied and they were satisfied in looking at the evidence that that hurdle was not overcome by a majority. My lady, in paragraph 84, we just summarise the material that was relied on in Shell and that was reviewed by the court, which is very similar, 85.4 on MS 97 and 98, which is very similar to the material in our case, in the Vedanta case, and in Unilever.
It's quite difficult to know what to do about these two cases. You must be right to refer to these passages, but we know that there are applications for permission pending.
Yes.
So we've got to treat this with a degree of caution.
Of course, my lord.
And insofar as this is Court of Appeal, obviously having a particular eye to what had been said in the Chandler case, we are perhaps not so constrained.
No, absolutely, my lord. The position is complicated a tiny bit by the fact that my learned friend is now relying on what Lord Justice Sales said in Unilever, and therefore he's seeking to put himself into that bracket. But while not, of course, bound by what the Court of Appeal said or by their approach, I do commend the approach that they did look at and subject the evidence to critical scrutiny in both cases. That we respectfully submit must be right. And secondly, the court will be interested to see how the Court of Appeal did approach very similar arguments and a very similar pleaded structure.
Yes.
And finally, 2 points on Shell. One further reference, which is paragraph 195 to 197 of the Shell judgment at MS 3374, commend to you what the Chancellor said. Having looked at very similar documents that are relied on in the claimant's pleading, he said, they demonstrate rather what I would expect from a commercial perspective. They show Royal Dutch Shell laid down detailed policies and practices as to management, oversight and engineering, which they expected their subsidiaries and joint ventures to follow. And then over the page, he said, it would be surprising if a parent company in paragraph 196 were to go to the trouble of establishing a network of overseas subsidiaries with their own management structures if it intended itself to assume responsibility for the operations of each of those subsidiaries. The corporate structure itself tends to militate against the requisite proximity. So I rely on all the same material as the claimants to say the Vedanta Sustainable Development Report, the Vedanta Sustainability Framework, the Vedanta Corporate Governance, all militates against the requisite proximity once it is subjected to critical analysis. The second point I need to alert you to, and I'll come to it in a moment further if I may, is that the Chancellor in Shell and Lord Justice Sales, who delivered the leading judgment in Unilever, both in finding there was no duty of care in those two cases, put Vedanta in the Chandler control category. And the reason they did that, in short, as can be seen from paragraph 84 of the Court of Appeal's judgment, you can have the reference please, in Vedanta, is that the Court of Appeal essentially did what the judge did at first instance, and without subjecting the evidence to any analysis, simply said there are various 6 factors which point to, in this case, a level of control and puts it in the bracket, a similar bracket to Chandler. And that's the factual material we have, with some trepidation, gone into to some extent in our case. Because when you look at it, it in fact boils down to a corporate structure and then, which I'll call category A, said to give rise to the assumption. And then secondly, and that although they're not pleaded, certain particular matters which my learned friends relies on to say this is evidence which does support the case against Vedanta in particular. And when one looks at that evidence, it's not pleaded, but that's not a problem from my point of view, because when one looks at it, it boils down to this. First of all, Vedanta has, over the years, carried out significant funding obligations for KCM. The funding it has carried out at arm's length is set out in the statement of Mr. Kumar. With respect, the fact that a parent company may fund a subsidiary cannot, we submit, give rise to a duty of care in respect of the entire operation of the subsidiary. So that point, which takes up a huge amount of paper, is a non-point. The second point relied on is a suite of agreements that KCM entered into with the Republic of Zambia, its shareholders, and Vedanta back in 2004, when VHRL, the subsidiary company which purchased the 50% shareholding originally in KCM, when those agreements went through, the Republic of Zambia wanted to ensure that certain funding commitments were abided by. There was a shareholders' agreement. I rely on the shareholders' agreement to show lack of control by Vedanta. Under the shareholders' agreement, Vedanta undertook, and I'm using shorthand, a commitment to carry out a feasibility study into the Konkola deep ore mine. In fact, it didn't, but there was a commitment that it would. That can't give rise to a duty in respect of operations for the next 15 years and going forward. Secondly, under the shareholders' agreement, it agreed to certain debt financing and cash shortfall obligations. And again, with respect, that cannot give rise to a duty in respect of operations going forward. The claimants then rely on an agreement which is not pleaded called the management agreement. KCM and Vedanta entered into a management agreement pursuant to which Vedanta agreed, Section 3 of the agreement, to provide at KCM's request certain advisory services up to a maximum of $1 million worth a year. The turnover of KCM is over $1 billion. The agreement specifies in Clause 8 that those services will be provided as an independent contractor. So I rely on that management agreement to demonstrate that Vedanta was not in control at any time of the management, even though it couldn't be lawfully, but it was not and didn't have the capacity to be, with its 19 employees, 11 directors, 9 directors, 11 administrative staff. But it is alleged against me in witness evidence that this shareholders' agreement, this management agreement, is, and I paraphrase, further evidence of Vedanta's control. So, deeply tiresome, but we have to exhibit the management agreement and the shareholders' agreement, put it before the court to demonstrate that those allegations have absolutely no substance. So what it amounts to is that this entire pleaded case of management takeover control is based on one, corporate governance and the framework, and two, funding and various assertions about those two agreements. Finally, the claimants rely on a statement from a Mr. Davies Kangela. And no disrespect to Mr. Kangela, it's a 7-page, 8-page statement. He was a middle manager working at one of the tailings plants during some of the period with which we're concerned, from 2005 all the way through to date. And he makes a number of statements in that, in his statement, to the effect that he couldn't tell the difference between Vedanta documentation and KCM documentation, that he felt that Vedanta, when Vedanta, as he puts it, took over, Vedanta employees came and worked, or persons from the Vedanta group came and worked for KCM. The generalized statements. I invite the court to look at it. The judge said this was a weighty piece of evidence. In Shell and Unilever, similar statements were also put in. Actually, they were more detailed in those cases. The Court of Appeal subjected them to critical analysis and concluded that they could not possibly, on any realistic assessment, be relied on to demonstrate the degree of management takeover required. So if you strip back all the paper, all the allegations, it can be boiled down to those documents and those propositions. But I totally accept we come back to the fundamental legal proposition and legal principle is this a recognized category of duty? It is not in my submission, unless one takes a very broad category along Smith and Middlewood's lines. Is the degree of control alleged in this case and arguable in this case sufficient in order to render it arguable that a relationship of proximity existed between those affected by the operations and Vedanta? And we respectfully submit, clearly no. May I just show you the duty as it's pleaded, so you can see. And this is where the Court of Appeal started, and you can see why I needed to show you why it's not Chandler. And the particulars of claim is in Core Volume 2. Divider 16. And it's MS 654. And it's paragraph 78. My ladies, paragraph 78, the duty is alleged to be a duty on Vedanta to take all reasonable steps to ensure that the claimants did not suffer foreseeable personal injury, damage to property, or economic loss. So one notes it is a very broad duty as a result of the discharge of harmful effluent from the mine into the waterways and the local environment. 79, the duty arose as a result of the first defendant's assumption of responsibility for ensuring that the second defendant's mining operations do not cause harm to the environment or local communities. As evidenced by the very high level of control and direction that the first defendant exercised at all material times, which is 2005 to date, over the mining operations, and please note this, my lady, of Vedanta and its compliance with applicable health, safety and environmental standards. So it's alleged that this duty is evidenced in part by its control over compliance, which flies in the face of the pleaded allegations relying on the corporate framework, which make it clear that compliance and implementation is for the local subsidiary, having regard to local laws and so on. And then we have the Chandler criteria. Further, alternatively, as a result of the first defendant's knowledge and control over the second defendant's operations, and their foreseeable effect on the environment and communities in the vicinity of the mine, there was a relationship of proximity between the first defendant and the claimants, and the imposition is fair, just, and reasonable. And then we see the Chandler criteria, we say wrongly, and as a matter of law, inappropriately relied on. It's simply averred the businesses of the first defendant and the second defendant are, in a relevant respect, the same. Namely, they're both involved in the business of mining. So, and this could be said of any multinational that has subsidiaries involved in different businesses. And this is relevant to Lord Justice Tomlinson's point, because same business was crucial to Lady Justice Arden when setting the criteria in Chandler, because that gave rise to the relevance of superior knowledge and reliance. So that's simply averred. We say that's demonstrably wrong. The first defendant knew or ought to have known that KCM's operations and equipment were unsafe. Third, the first defendant, and here again, had or ought to have had superior knowledge. There's absolutely no basis at all for an allegation that the parent company, in this case, or in Shell or in Unilever, has superior knowledge in the sense that Lady Justice Arden was referring to in Chandler as to how to operate a mine in Chingola in Zambia in circumstances where KCM and its employees have been building up knowledge for decades. And then please note this, given that this is an assumption of responsibility pleading, D, the first defendant knew or ought to have foreseen that the second defendant would rely on the first defendant's superior expertise, knowledge, and resources. So it's a bootstraps pleading. And the reliance, which is normally so crucial to an assumption of responsibility type of category of liability, is in fact pleaded as the reliance by KCM and not any reliance by the claimants. So that is the case. And essentially, Mr. Justice Coulson, the Court of Appeal, said that's sufficient. That's arguable. You've had my submissions on that. If I could just break down, my lady, that the pleading then sets out the evidential assertions relied on in respect of the Chandler criteria and the allegations of control. I hope helpfully we have, as Appendix 1 to our document, to our case, included a document which identifies each paragraph, and it gives the court the evidential reference for where it's dealt with. And we've updated that, and we'll hand up, if we may, an updated version of that which has the MS numbers. So we've taken each paragraph.
You're going to hand it out to people who use screens, it would be better if you emailed it to us rather than gave it
Right,
to
I'll
somebody.
do that, my lord, yes. And you'll see that the claimants rely on, in particular, a document called the Sustainability Development Report, which is produced in order to describe the group's activities. And they quote various sections of it. And it's very important that one sees those in context. I rely on them, but we've also produced a document which we will send to the court, which gives you the page number of where that quote is in the report, so you can see quickly where it is. But just to boil it down, and treading softly, I hope, paragraph 83 is the facts and matters. This is also relevant to the statutory duty when I come to it. The facts and matters that they will rely on, as you can see, the first defendant's assumption of responsibility and control over health, safety and environmental matters at the Lachanga mine. And then you see there are particulars that run forward over a number of pages to MS 660. There are 13 particulars. 10 of the 13 are quotations from the Sustainable Development Report. And essentially, and the other 3 particulars simply set out, this is the Vedanta corporate governance framework. So all the particulars relied on in order to demonstrate proximity, control, are in a sentence, Vedanta's sustainability framework and its corporate governance framework. That is, we've explained, it's in the evidence of Mr. Kumar from the point of view of KCM. It's in the evidence of Mr. Ndolo from the point of view, Mr. Kumar from the point of view of Vedanta, and Mr. Ndulu from the point of view of KCM. And in our case, we summarize that corporate structure and framework with the relevant references at paragraph 48 through to paragraph 65, MS 81 to 87. So, you can see, for example, to give you one example of this section, and then I can move on to the next one. E, on MS 657, the first defendant established a sustainable development framework which binds all of the first defendant's subsidiaries. That's on page 657, letter E. And which is overseen by the first defendant through an internal verification process. So that is correct, and we rely on that. What this recitation of the framework fails to do, and we've done it in our evidence, is actually explain how it works at subsidiary level. And that's obviously important in circumstances where it's said that this framework gives rise to control, but there can be no dispute because it's in the documents that at subsidiary level, as I've said, it's for the individual subsidiaries to ensure that if there is a group policy, for example, in respect of best practice at work or best environmental practice, the local subsidiary, such as KCM, has to tailor that broad policy to its own particular obligations. And KCM in Zambia is heavily regulated by the Zambian government, the Environmental Council, and it can only operate the mine in accordance with a license, which only a Zambian company is allowed to do. And the waste, which is the subject of the alleged pollution in this case, is itself the subject of waste licenses, and levels of waste emissions are permitted, but they have to be treated such that chemicals remain at a particular level. All of that is explained in our factual summary of the facts, and we've put the licenses in the bundle, I fear, because they do demonstrate just how heavily regulated the work, the mining operation of KCM is. And yet it is said in this case that this is an arguable duty that Vedanta effectively took over to a greater or lesser extent that operation. So That is the
Is
paragraph.
breach of the Zambian regulations a criminal offence?
Yes. It's a criminal offence under the Mine and Mineral Developments Act 2008, I think. Can you check that?
Yes.
Which we will come to. It's a criminal offence, and those statutes ought to give rise to strict liability on the part of KCM and indeed other mining operations. So that is the pleaded case on control. That's what it amounts to. You then come to, and I can deal with this very quickly, the attempt to shoehorn this duty into Chandler, because at paragraph 84, MS 661, you see the heading. The first defendant's superior knowledge and resources concerning relevant aspects, and note, it's health, safety and environmental practices. So this isn't just a duty in respect of the emissions alleged to have caused damage to land in this case. It's a duty that extends to all matters covered by the health, safety and environmental policies which are supervised by the Sustainability Committee, of which environmental practice is one. And this is what they rely on, and one compares this with Chandler for superior knowledge, superior expertise. 84A, the facts and matters set out at 83, which is what I've just shown you, which is the framework. Then public statements that it's invested heavily. Then it said at B that there are other subsidiaries in the group in Australia and India where there are copper mines. And on the basis of that allegation, there could be some superior knowledge. And there's a further allegation about investment. So in my submission, that type of allegation, if that is where the bar is for superior knowledge, it would be met by almost any multinational at any time. Then there are various allegations under the next Chandler rubric: first defendant's knowledge of the second defendant's unsafe, this is MS 662, paragraph 85, unsafe and environmentally harmful mining practices. So essentially, a number of statements are pleaded, public statements, where it's there have been descriptions of issues occurring at the mine of a different type. There's reliance on visits and some twin and some co-directorships. No member of the Vedanta board is an executive director of KCM. There are 2 non-executive directors. And then finally, one gets to the critical, I would respectfully say, paragraph, given this is an assumption of responsibility of reliance, and that is at paragraph 86, MS 665, the first defendant's, Vedanta's, knowledge that KCM would rely on the first defendant's superior expertise, knowledge and resources concerning relevant aspects of health and safety. And they list all the previous factors, and this is why I opened it in the way I did, my lady. In the fourth line of 86A, in light of the detailed guidance and policies established by Vedanta, it is to be inferred that the second defendant would necessarily have relied on the first defendant's expertise and knowledge in relation to the obligations towards the communities in the vicinity of the mine. And before that, in the first sentence, it is alleged that the factors 83 to 85, to which I've drawn your attention, demonstrate the overarching control, management, and oversight that the first defendant exerts over its subsidiaries, compliance with health, safety, and environmental standards. So, that is the pleaded case. And I appreciate, of course, duty is one thing, breach is another, but I invite you to look at the allegations of breach simply because they show what would be necessary to discharge this duty and give further insight into the nature of it. And they are at paragraph 89, MS 668, over the page. And if you look at them, 89, first of all, B to H, they are treating Vedanta in effect, well, they are alleging that Vedanta is responsible for all for a series of operational failures. For example, F, failing to ensure that KCM notified ZEMA, that is the local regulator, the Zambian Environmental Management Agency, of spillages and non-compliant discharges within 24 hours of any spill. C, failing to take adequate measures to prevent numerous non-compliant mining effluent discharges and spills. So, on the basis of the group-wide framework, this is the nature of the breaches alleged, effectively treating Vedanta as if it is doing something it can't lawfully do, and suddenly doesn't have the resources to do, namely operate the mine. And then note A, failing to ensure that KCM had in place adequate systems and policies, and or failing to ensure that the second defendant implemented them. So it's an omission duty. You should have intervened in order to ensure that KCM did have appropriate policies in place. There's no allegation in this pleading that the policies disseminated by Vedanta are inadequate or inappropriate, as you've seen. But it's nonetheless alleged. In effect, it boils down to this. There's been pollution, we contend. It follows either the policies were inadequate or you failed to implement them. And yet, at one and the same time as saying that, the claimants are relying in the pleading I've taken you to the corporate sustainability framework, which expressly makes it the obligation of the subsidiaries to put in place their own policies. So, my lady, we say that this duty is incoherent. You'll note, if I may just make some submissions in relation to it, and this builds on our written case at paragraphs 66 to 71, MS 87 to 90. It's not alleged that Vedanta owes this duty where we make overarching points. It's not alleged that Vedanta owes this duty under principles of vicarious liability, agency, joint enterprise, or conspiracy. It's not alleged that the corporate veil should be pierced. So there's no allegation that KCM is not managing its business as it should be in that sense. It's not pleaded, as you've seen, as a negligent advice case or a negligent failure to provide certain services or any case of that type. Since it's based on the government's framework that is applicable to all subsidiaries, the same duty would be owed to anyone employed by or harmed by the operations worldwide. The Chandler criteria are wrongly being relied on and shoehorned in order to make out proximity when they don't apply properly to the facts of this case. It's a duty that would require Vedanta, a parent company with 19 employees, to intervene worldwide, put it in a position of proximity with its 80,000 employees and hundreds of thousands of people affected. The breaches, as you've seen, effectively treat Vedanta as a de facto occupier or employer on the one hand, and at one and the same time as being under a duty to intervene because the mine is not being appropriately managed. As I've said, there's no allegation that any of the policies issued by Vedanta are inadequate. And there is a further problem with the duty, and it's that the framework that is relied on came into effect in 2011. This duty is alleged to have existed from 2005, and in 2005 to 2011, Vedanta, the parent company, issued 6 broad statements of principle. That was all, broadly speaking, that was done, and the individual subsidiaries were under an obligation to tailor them to their local circumstances. So in essence, the new framework was the same, but more detailed. But there's no attempt to differentiate between these two time periods. So what my learned friend now says, despite the way the case is actually put and pleaded, is that this is a management takeover, a management control duty. And in my submission, there is no pleading to that effect, and that actually flies in the face of the very framework that he is relying on. And if we go back to our case, just to look at where he gets that from, the Unilever decision, which we deal with at paragraph 87 of our case. I don't think it's necessary to go to it, my lady, but for your note, it is at Authority Bundle 1, tab 5, 3074, MS 3074.
Well, I've been reading it.
We set out the facts of that case at paragraph 87. And as you can see from paragraph 87 and the summary of the facts we set out
Do you
there.
take any issue with Lord Justice Sale's statement of principle in paragraph 36 of Unilever?
No, my lady.
So that's the question of law.
Well, my lady, yes, of course, but the question is also, if I may respectfully say so, whether the claimants have satisfied the burden.
Well, I appreciate that that's what you're on about.
And
we're interested in the question of principle.
yes. Well, in terms of principle, I've sought to show what it's not. And my lady, yes, I see the legal point, but that's not the way the case is pleaded. The important bit is the next bit, which we set out at paragraph 90. What Lord Justice Sales explains is that parent company duty care cases fall into 2 categories: management takeover or advice as to a specific risk category. And this is paragraph 37 of that judgment. And he says, and if I may, it's paragraph 90 of our case, it may be that on the facts of a particular case, a parent company having greater scope to intervene in the affairs of its subsidiary than another, and I underline these words, my lady, has taken action. Of a kind which is capable of meeting the relevant test for the imposition of a duty of care in respect of the parent. The cases where this might be capable of being alleged will usually fall into two basic types. One, where the parent has in substance taken over the management of the relevant activity of the subsidiary in place of or jointly with the subsidiary's own management. And as I said earlier, he quotes Vedanta as an example of that, and I've perhaps been labouring the point because it's crucial that I demonstrate to you that Vedanta is clearly not an example of that type of case. And secondly, where the parent has given relevant advice to the subsidiary about how it should manage a particular risk.
The reason I'm terribly sorry for
That's right, ma'am.
interrupting you. The reason that I asked you
Yes.
Was paragraph 36 says there's no special doctrine in the law
Yes.
of tort of legal responsibility on the part of a parent company in relation to the activities of its subsidiary vis-a-vis persons affected by those activities, etc., etc. He goes on, says it's governed by the ordinary law.
Yes.
In paragraph 37, he's talking about the sorts of facts that might give rise to a duty. He's not stating principles of law there. He's giving examples of the sorts of situations in which a duty might arise. Just as some would think Lady Justice Arden in Chandler was giving examples of the circumstances, she calls them the circumstances in which a duty might arise. It doesn't read as if it's an exhaustive statement of everything that's required.
My lady, I entirely accept it's not intended to be an exhaustive statement, but in my submission, if one is seeking to apply the incremental approach, one is looking for existing analogous categories of cases where the alleged duty has been held to exist. And crucial to that approach is to seek to analyse and discern the significant legal facts which gave rise to that category of duty. So, my lady, I would respectfully submit that in this situation, we don't have an established category: doctor, patient, teacher, pupil, occupier, visitor. We have two entities, and one is looking to see whether the allegations that are made bring those entities within what might have been termed or is termed a proximate relationship. Because the duty we know is a duty to intervene, to prevent KCM causing harm. So that is, as Lady Justice Arden was saying in Chandler, appreciate different facts, but that is the starting point for this duty, and you can see that's the way it's pleaded. So if one is, to take Lord Wilson's point, looking to see whether this is either an existing duty or a novel duty, and if it's novel, whether there should be an incremental and cautious development, the starting point is to identify whether there has been any duty in which similar significant facts have given rise to proximity in the past. And in my submission, there is none. And this is, in my submission, an error of law to say that the category is parent company liability, or whatever you call it, a relationship. The rest turns on the facts, because that begs the question as what is it about that relationship which has given rise to the duty in the past. So I think what Lord Justice Sales is saying here is that, yes, my lady, you're looking for existing categories. If a claimant in a parent company case can demonstrate a management takeover, and there's sufficient facts, allegations and facts to demonstrate that, then legally that is a category of duty that is recognised, because the relevance of that articulation being, it's then possible to see arguably why there may be a relationship of proximity between those affected by the operations and the parent company. But without the management takeover, without that degree of involvement, as the Chancellor was saying in Shell, it's not arguable that there will be the proximity. That has been my learned friend's case to date in this matter. It's arguable. We allege de facto control. The rest is fact. It's not appropriate to go there. That's why we're here. And it's what the Court of Appeal refused to do in Shell and Unilever. And in terms of the my lady, I respectfully submit this is, in fact, in terms of the legal approach, a paradigm example of the importance of the very legal approach that this court has been advocating in recent decisions, Robinson, Michael, Darnley, ensuring that there is a proper analysis of the significant facts in the existing cases. Moving away from simply starting with Caparo and treating it as a broad test. And I appreciate it in cases like Darnley and other cases, it's possible to say, well, there is a recognized category, doctor-patient. But with respect, that's not the position here. One has to look at why it is this relationship is likely to trigger a duty. And my lady, the short point is, I appreciate as a matter of law we respectfully submit that on the basis of the way it's pleaded, it is not arguable. It's interesting in terms of the advice category, and we set it out, again, what Lord Justice Sales says at paragraph 92 of our case. He gives an example, and one sees this is closer perhaps to what Lady Justice Arden had in mind in Chandler. Such a case might include the situation, for example, where a parent required its subsidiaries or franchisees to manufacture or fabricate a product in a particular way and actively enforce that requirement, which turned out to be harmful to health. One might suggest a food product that injured many but was created according to a prescriptive recipe provided by the parent. May I just highlight, because it's relevant to the reference document we hand up, at paragraph 110 of our case, MS also 1110, and in the subsequent paragraphs, that is where we deal with the 6 types of evidence, including the management agreement, the shareholders agreement, and the other matters that I touched on earlier, which the Court of Appeal identified without investigating as being evidence that the claimants relied on in this case to support their duty. And we deal with each of them, and you can see that they fall, as I said earlier, into 2 categories. 1, the framework, and 2, specific matters, the management agreement, and so on. And none of them in my submission demonstrate what my learned friend is trying to show, which is the requisite degree of arguable control. My lady, would you give me one moment? Just to check where I am. My ladies, my lords, we deal finally with why the alleged duty we submit would not be an incremental development of the law at paragraph 159 of our case. And my lady, I'm conscious that these legal principles are familiar to the court, but we make the point that at A, that this is an assumption of responsibility case, and it certainly doesn't fit into any similar category of control that has been, where such an assumption has been found in previous cases. We deal with the further issue of coherence at B, undermining the principle of corporate separateness. I appreciate the claimants, as Lady Justice Arden underlined, are not seeking to pierce the corporate veil, but the reality is, if this duty exists, it is very difficult to see how it fits with important principles of corporate separateness, which of course underpinned commercial dealings, and indeed the long-standing Court of Appeal decision in Adams and Cape. And in short, as we submit at C, if there is to be a major, and we would say very significant and substantial extension, it is a matter for Parliament. My lady, you'll have seen the interveners' submissions, and they, as you can see, suggest that this is a change to the nature of corporate responsibility. It should be advocated at this stage, but we respectfully submit that it would not be an incremental change. If the type of change that they are advocating were to be given life, it would be a major leap.
They collect, you're talking about the first and second interveners, aren't you?
Yes, I am, yes.
They collect together quite a lot of material indicating a particular direction of international travel.
Yes.
Don't they, Mr. Gibson?
Yes, they do. They do. And that travel, for the most part at the moment, is through voluntary guidelines. I would urge the court, as we've to consider the categories that we've been looking at and the serious difficulties that would ensue if the allegations that are made gave rise to a duty of the nature and scope to claimants of this type for which the claimants argue.
Quite specific material in, if you remember, General Comment number 24 on the part of the UN Committee on Economic, Social and Cultural Rights, which we've got, of course, in Supplementary Volume 1, MS 26, paragraph 24B, 2 and 3, and 4.
Yes. Could you just give me the paragraph number again?
Of course. 24B,
Yes.
2, 3 and 4. Supplementary Volume 1, page 27.
Yes. These are obligations on states.
Quite. The state parties include us? Are we part of the state for the purposes of deciding how far the law should go?
I'd have to come back to you on that.
Yes. Very well, thank you.
My lady, my lords, for those reasons, we respectfully submit the claimants have not established a realistic prospect. The test being applied, that this duty, the common law duty they argue for, is owed, and it's agreed that if it's not owed under English law, then it's not owed under Zambian law. So we then come to the statutory duty claims. And if you please turn to our case at paragraph 185, MS page number 135. I'm just going to show you in a moment how the statutory duty claims arise in the pleading, because essentially the statutory duty claims we submit are pleaded, and indeed the Zambian expert evidence supporting them makes it clear that it is entirely dependent on establishing the facts and matters alleged in respect of the assumption of responsibility underpinning the common law duty claims. As we say in paragraph 85 of our case, paragraphs 90 to 94 of the particulars of claim allege that Vedanta is strictly liable. Paragraph 185, sorry.
MS 135.
MS 135. They allege that Vedanta is strictly liable to the claimants under 4 statutes: the Mines and Minerals Development Act 2008, the Environmental Management Act 2011, and the Environmental Protection and Pollution Control Act 1990. The 4th, the Public Health Act, it's accepted, does not give rise to a claim. So it's only the 3 above that remaining. And if we could go to the particulars of claim, to paragraph 91, so I can just show you how these claims are made, and I'm going to deal with this topic very briefly. It's MS 669, paragraph 91, the particulars of claim in core volume 2, tab 16, MS 669. So in the pleading, I took you to the particulars of negligence in respect of the common law claim, which was paragraph 89, the paragraph 2 before, and then paragraph 90 is liability under the Zambian statute law. And you'll see the Mines and Minerals Development Act, the Environmental Management Act, and the 1990 Pollution Act over the page. And you'll see, and I can take one as an example, each paragraph begins, in light of the matters pleaded above, and the first defendant's direction and control over the operations of the second defendant, the first defendant is responsible, and then it goes on to say, and is therefore strictly liable, and exactly the same wording is used to introduce the claim under each statute. First point, Mr. Mwenue, the claimant's expert, has accepted in his report that these statutes do not give rise to a strict liability claim. So the claim as pleaded is bound to fail in each case. But my learned friend says, well, we can amend to say, to delete the word strictly. Because our expert says, provided we prove fault, then there will arguably be a claim subject to proof of all the previous facts and matters. The claimants haven't sought permission to plead. This is a jurisdiction application. The court only has the pleading. But if that isn't conclusive of the matter, my main point is that the pleading, and I'll show you the expert evidence by reference to our case in a moment, is expressed to be entirely contingent on the claimants demonstrating the facts and matters alleged above that we've been looking at. Now, to save going to the report, let me show you how this is dealt with in the report by going to my case at MS 139, paragraph 197, or the paragraph above 196. This is an extract from Mr. Mwenwe's report, and he uses the same wording for each statutory claim. So the one we're looking at in 196 at the top of MS 139 is the claim under the Mines and Minerals Development Act, and what he says is, after having considered the contents of paragraph 83 of the particulars of claim, which is the paragraph I took you to containing all the allegations of knowledge relying on the corporate structure, if the allegations made against Vedanta on its assumption of responsibility and control of KCM's health, safety and environmental standards were to be proved, a case could be made out. And you'll see for the next one, if the allegations Vedanta assumed responsibility and so on. So I'm positing, clearly as the position that the courts below faced was that they were satisfied that the case, the assumption of responsibility case was arguable. And it was therefore dealt with very briefly by both courts, who essentially said the expert says on that basis it's arguable, that is sufficient. I'm positing now a situation where this court finds that the facts and matters alleged in respect of assumption of responsibility do not give rise to an assumption of responsibility, a legally significant assumption of responsibility, do not give rise to allegations of direction and control such that the defendant is liable, as alleged in the breach paragraphs at 190, for failing in effect to ensure that the mine is operated without permitting emissions to be caused. And those are the allegations of breach that I took you to in paragraph 89. So my learned friend is portraying this as a dispute between the experts. My expert, Chief Justice Sakala, does not accept this interpretation of the statutes in any event, and there's an issue between them. But I am not asking the court, and I was not asking the courts below, and the courts below did not have the same issue before them in view of their findings on the duty. I'm not asking you to determine whether one expert of Zambian law is right over another. And I appreciate that is not something that you would be able to do unless you considered that the reasoning of the Zambian law expert was so obviously irrational or lacking in any reasoning. So I'm simply relying on what Mr. Mwenwe himself says and what is fed into the pleading. It's pleaded as strict liability, and that we know is wrong. You've seen the paragraph, and it's simply therefore being alleged that there is a realistic prospect of establishing that these statutory duties are owed, even if the court finds against the claimants on all of the allegations of direction and control and assumption of responsibility in the earlier paragraphs. And in my submission, Mr. Mwenwe has provided no other explanation as to how these statutory duties could be owed. He hasn't said, for example, if certain facts and matters were established, then the statutory duty would be owed. He's aligned himself completely and contingently upon not just establishing the facts, but the matters. And indeed, in this part of his report, he uses the phrase, as you've seen, assumption of responsibility. And he uses that phrase because in earlier parts of his report, in paragraph 50 and thereabouts, he analyses Chandler. And by the time he moves to the statutory duty claims, he has already concluded that as a matter of Kenyan law, Zambian law, the Chandler duty is arguably owed in this case. And he goes through the Chandler criteria and says in his opinion that as a matter of law, he considers they apply to this case, superior knowledge, same business, and so on. And on that basis, he concludes that the Chandler duty would be owed broadly, or a duty of care applying Caparo and Chandler would be owed, and the assumption of responsibility would be made out. Then later, for statutory duty, he uses the wording that I've shown you, without any further explanation or delineation. So in those circumstances, we respectfully submit that it's not necessary for there to be any expert determination on the basis of the claimant's case as pleaded, even if they are permitted to proceed with a claim that is, at the moment, has no prospect as it's in strict liability, and they're allowed to rely on their expert further. His support, qualified as it is, must stand or fall with the court's findings on duty. I'm not suggesting, my learned friend characterises this as suggesting it's necessary for there to be a finding of that a duty of care at common law is owed. I appreciate that they're different, but he does not seek in any way to distinguish between the facts and matters relevant for the common law duty or the statutory duty. So my learned friend leads with his statutory duty case and spends relative amount of time on it because he wishes to portray it as an argument between experts, which it's not. So, my lady, those are my submissions on the statutory duty claim. If those submissions are correct, then the claimants will have failed to establish that there is a real issue which it's reasonable for the court to try as between Vedanta and the claimants, and it wouldn't be necessary to proceed further. So I now proceed to the next issue, which we look at on the assumption that the claimants have passed through the gateway, the necessary or proper party gateway. So we assume that they have established that there is a real issue which it is reasonable for the court to try, and there is no issue that applying English laws of joinder in those circumstances, KCM would be a necessary or proper party. And if you'd please go to my case. At tab E4, paragraph 219, this is where we deal with this ground of appeal, ground 2. Called the proper place ground, and it concerns the proper approach to the test under CPR 637(3). I propose to address this topic, subject to the court if I may, under 3 broad headings: an overview of our position, secondly, to identify what we say are significant errors of legal principle, and then identify how we say the evaluative exercise under the rule should have been carried out had the legal principle been applied. And my lady, I I didn't make the point in relation to ground one, and I appreciate it's a point that needs to be underlined in each ground. I of course, have well in mind the words of this court in relation to the need to identify significant points of principle, particularly if one is seeking to review at an appellate level an evaluative exercise. But on this ground, we do submit that there has been some fundamental errors in the proper legal approach to this gateway, and it is as a result of that that I will seek to show you how the evaluative exercise we submit should have been carried out, which wasn't. So by way of overview, I identified one assumption which we need to make, which is that they've passed through the real issue proper party gateway. The second assumption is that the claimants can obtain substantial justice in Zambia, which is the subject of ground 3, and we deal with that next. And third, that the judge was correct to find that the court cannot stay the claims against Vedanta, which is ground 5, our Vedanta appeal. So I'm accepting for the purposes of this argument that Vedanta, as it were, is here. It's been sued as of right in this jurisdiction. So by way of overview, the statutory test in CPR 637.3 is in clear and mandatory terms. The court will not give permission unless satisfied that England and Wales is the proper place in which to bring the claim. That is the test, and as Lord Gough emphasised in Spiliada, and has more recently been undermined by this court in VTB and by the Privy Council in Ultimo, in a service out case, the court is enjoined not to permit service out on a foreign defendant unless satisfied that England is the proper place to bring the claim against that foreign defendant in the interests of all the parties and the ends of justice. That is the fundamental principle as Lord Gough described it in Spiliada. And the burden is on the claimant to persuade the court that England is clearly the appropriate forum. My lady, these claims have very unusual forum features, certainly features that have never featured in any appeal to this court before. 1,800 residents of a foreign state are seeking to found jurisdiction for a group action for their claims against KCM and for the claims of those who seek to join the group. 1. 2. All claim in respect of damage to land and waterways and injuries to their person sustained in that state. 3, against a defendant domiciled in that state. 4, in respect of torts alleged to have been committed exclusively at a mine in that state. 5, which mine is operated pursuant to statutory authority, backed by criminal sanctions, and regulated by that state. And 6, where all causes of action are governed by the law of that state. So these claims we submit give rise to completely different forum considerations to the cases which the judge directed, we say misdirected, himself to follow, and the Court of Appeal accepted was the right approach, namely commercial cases, usually involving international shipping, insurance, conspiracy, and cartel claims, which often involve no natural forum or no natural forum available to all the parties. My lady, the judge found that Zambia is overwhelmingly the natural forum for these claims, and the claimants do not challenge that finding. Nonetheless, he reached the conclusion that England is the proper place to bring the claims against KCM on one ground, namely to avoid the risk of parallel proceedings against KCM in Zambia. Or more precisely, due to, first, the claimant's lawyers' expressed intention to continue with their claims in England against Vedanta, and an assumption that there would be a risk of parallel proceedings in Zambia if service on KSM were to be refused. We say that the entire approach of the courts below was wrong in principle. This is not clearly a borderline case. Given the strength of the natural forum arguments, if the judge's approach and the Court of Appeal's approach is correct, then the statutory forum requirement we submit ceases to play any meaningful role under this gateway, where there is an anchor defendant domiciled in England. It will become the norm to require foreign defendants to defend even land-placed group claims of this type in England. We submit that that is not the law. The correct principle which should inform the evaluative exercise was that stated by Lord Justice Lloyd in the Goldian Mariner and emphasised by Lord Collins in the Ultimo, at paragraph 73, MS 3095, that caution must always be exercised under this gateway, and that it must never become the practice to bring foreign defendants here as a matter of course on the ground that the only alternative requires more than one suit in more than one jurisdiction. We say that it was a significant error for the judge and for the Court of Appeal to agree that the existence of the claim against Vedanta, absent exceptional reasons, that was the words he used, virtually concluded the issue in favour of England being the proper place. The effect of that misdirection was that he failed to carry out any meaningful evaluative exercise, and certainly not one which had any proper regard to the interests of each of the parties and the ends of justice. I'll turn in more detail to that exercise, but finally, by way of overview, we submit that if the courts below had carried out the requisite exercise, they would have determined what weight and importance to attach to various factors, which I will highlight, but they include, first, there is no significant prejudice to the claimants if the claims against KCM are not brought in England. The claimants can either sue KCM or KCM and Vedanta in Zambia, or they can proceed with their claims against Vedanta in England in isolation. And second, by way of overview, the court should and would have taken into account, properly directed, the serious and incurable prejudice which will be caused to KCM if required to defend this open-ended group action, and I'll explain that in due course, in the forum non-conveniens. In short, if the judge had undertaken the requisite evaluative exercise in accordance with the fundamental principle, and there was no weighing exercise, we submit that the scales are so firmly weighted in this case in favour of Zambia being the proper place to bring the claims, the single factor of claims proceeding against Vedanta in England should not outweigh all other factors. So, my lady, that is our position in overview. May I turn to the significant errors of principle of the courts below, without going to the judgment. We've identified them in our case, but there are four. And the first I've already touched on. And I'm looking at the judge's misdirections because, as I say, the Court of Appeal at paragraph 117, MS 419, essentially said that the judge was entitled to the view that it was inappropriate for litigation to be conducted in parallel proceedings. So they essentially adopted his approach. So the first error we submit was the judge's direction at paragraph 60, MS 459, which we refer to at paragraph 231.2 of our case, MS 152, namely the fact that the claim against Vedanta, and I quote, virtually concludes the issue in the absence of exceptional reasons the other way. That, in our submission, was the wrong starting point. Having taken that starting point, he then focused on 2 points that he considered might be exceptional reasons. One, whether the claim against Vedanta was a device, and two, whether the court should accept the claimant's lawyer's contentions that they would continue with the claim against Vedanta. And my learned friends continue to seek to focus the argument on these points. In our submission, his point of departure was wrong. The mere facts of the claim against Vedanta cannot by itself reverse the conclusion that Zambia is the proper place. The task of the court is to consider all the relevant factors and to weigh them against each other, having regard to the underlying principle.
Oh, Mr. Justice Coulson didn't let it conclude it, if you look at paragraph 167 of his judgment. He said it's plainly a highly significant factor.
He said that, but in my respectful submission, when one looks at the way he approached the issues, in fact, he treated...
Well, that's different from getting the test wrong. It's applying it wrongly.
Well, we respectfully submit it's a combination, because if one goes to his judgment, at paragraph 161, yes. He says there, he's referring back to the commercial cases, and in particular Mr. Justice Leggett's decision in OJSC. And Mr. Justice Leggett had said in OJSC that if it's a device, that would be a weighty factor in favour of not granting permission. He then went on in 160 and said, in the absence of an exceptional reason the other way, does the existence of the claim against Vedanta virtually conclude the issue as to forum? And he said, on the face of it, it does. So he said to him, he directed himself, on the face of it does, and it's at that point he then looked for exceptional reasons.
Well, he looked at the two particular points upon which KCM relied.
Yes, they were not the only. We were seeking to argue that there should be an evaluative exercise exactly as here. In fairness, that was mischaracterizing our arguments. We were certainly advancing the argument that it was a device, but we weren't saying that that was the conclusive issue. In other words, device or no device, you don't need to carry out an evaluative exercise. So what he does is to say, does it virtually conclude it? No, yes, unless there are exceptional reasons. He then looks at two, what he calls exceptional reasons. One is the device. He says it's not a device because there are other reasons for suing Vedanta. And then the second submission at 164, that, which was one of the submissions that was made, I accept that the court shouldn't simply rely on the claimant's lawyer's assertion that they are proceeding with their claim against Vedanta. So in effect, having dismissed those two exceptional reasons, at 167 he says, it may be that Mr. Justice Cook slightly overstated it when he said that the existence of a claim virtually concludes the question, but it's plainly a highly significant factor, and then I can see no sensible alternative. And our complaint is that as a result, he didn't do what he should have done with respect, which is to apply the fundamental principle at that point and say, the motive is a factor, whether it's a device, whether it's a reason, it's just one factor. But the question for me, applying the fundamental principle, is having regard to the interests of the parties and the ends of justice, weighing these factors, what is the answer to the statutory test? And what one doesn't see, we submit in this judgment, is any weighing. It's almost a binary choice. And of course, no criticism, but the claimants would say they're going to proceed with their claim against Vedanta. They're entitled to say that. They sued Vedanta as of right. So we submit that is both a misapplication of the test, but he did also take the wrong point of departure. And the net effect of it, and this is what we submit, entitles this court to intervene at an appellate level, is that he did not carry out the evaluative exercise in accordance with the fundamental principle. One gets further insight into his approach to the test from the second error we rely on, which is in paragraph 231.1, I'm sorry, on page 152, MS 152 of our case. At an earlier part of his judgment, paragraphs 41 to 42, MS 436, he dealt with various submissions about the Owusu factor, the fact that Vedanta can't bring a forum non-conveniens claim on this assumption against, I'll take you to it, my lady. It's paragraph 42.
436.
MS 436. He quoted Lord Justice Lloyd at paragraph 41, as you can see. It must never become the practice. And then he said, this problem has arisen in this and other cases, but much has changed since 1990. He refers to Owusu and Jackson. In this way, the principles noted by Lord Mance in VTB and Lord Justice Lloyd never really arise. And if you go over the page at paragraph 44, he talks about the fundamental, what he calls the distortion, which we submit underpins the broader forum submissions, namely the decision of the Court of Appeal in Chandler, which opens up the possibility of arguing a parent company has a freestanding liability. So the bar is very low to get over the real issue test. And then as he goes on, having quoted from Dr. Andrew Sanger, speaking of Chandler, it is the combination of Owusu versus Jackson on the one hand and Chandler and Cape on the other that underpin the vast majority of Mr. Hermer's submissions. In essence, although he was too polite to say so directly, his submission was that this court has no option but to refuse both these applications and to accept jurisdiction to deal with these proceedings as they are presently constituted. And I know language such as it weighs heavily and so on is perfectly properly and rightly used, but the reality is that this is what commentators mean by the Owusu factor. Vedanta cannot get a stay as a result of Owusu. Vedanta is therefore here. Vedanta, the foreign defendant is a necessary or proper party to the claim. It said Vedanta is sued as of right. We're proceeding against Vedanta. That is our intention. There's therefore a risk of parallel proceedings. That virtually concludes it. Now, on our second error, we submit that, with respect, the judge was wrong to say that the principles of Lord Justice Lloyd, as recently approved by Lord Collins in Ultimo, never arise. They do. We submit that they arise even more importantly when one's considering this gateway than they did before Owusu, when the anchor defendant could, of course, apply for a stay on foreign non-convenience grounds. As we say in paragraph 233 of our case, MS 153, and as Lord Collins explained in Ultimo, caution will always be required under this gateway because, unlike the other gateways, it's not founded upon any territorial connection between the claim, the subject matter of the relevant action, and the jurisdiction of the English High Court. So we respectfully submit that the Owusu factor, such as it is, requires the court to place more weight, not less, on the principle set out by Lord Justice Lloyd, exercise greater caution, and in fact, of course, the statutory rule and the wording of the rule itself surely lends itself to that construction, the mandatory and clear terms, and does provide vital protection to ensure that foreign defendants are not required to defend claims in the wrong forum under this gateway. So that, we submit, was his second error of principle and the erroneous misdirection which led him to allow the existence of the claim virtually to conclude the matter against Vedanta. The third error, and this, as you can see from the judgment, heavily weighed in his approach, and my learned friend seeks to emphasize, and that is that he took into account commercial cases, particularly OJSC, in which the existence of a claim against one defendant in this jurisdiction had, as Mr. Justice Cook said, virtually concluded the matter. And in short, we submit that those cases, those commercial cases, give rise to wholly different considerations to the type of forum issues that this prospective group action gives rise to, and yet they were treated as very influential. If one looks at the cases he relied on in his judgment at paragraph 157, there were two sets of cases, the Eel actions and the Baltic Flame. We addressed those in our case at paragraph 237, MS 154. But the short point is, in the Baltic Flame, as Lord Justice Potter remarked, it was an international commercial case in which there was no natural forum. As he described it at paragraph 19, MS 5610, international litigation without a natural forum. The Credit Agricole, Mr. Justice Cook's decision, was an international conspiracy claim involving 9 defendants. One of the 9 sought to resist service out on the basis that Kenya was the proper forum. And in that particular case, having regard to a number of facts and circumstances, perhaps not surprisingly, the fact that the claim was going on in this jurisdiction against the other 8 defendants proved to virtually conclude the matter. So, and one can make the same points about the 6 new commercial cases that my learned friend has now referred to in his own case at paragraph 178, MS 340. They're all international commercial cases, either of no natural forum or where there is not an available forum, i.e. one where all the parties can be sued together. So our short point is these cases turn on their own facts and should not be treated as determinative or heavily weighed in favour of the claimant's position when dealing with a forum application of this type of case.
That sounds like a very convenient moment.
It is, my lady. We're on the law, my lady.
Well, thank you very much indeed. We'll adjourn now and look forward to hearing from you again at 2:00.